The mining company Gold One outside Springs has now confirmed firing 401 workers who it says were involved in an illegal protest underground last year. At the time, the mine said some mine workers had taken other workers hostage, and that it was AMCU members who were taking hostages. AMCU strongly denied that, saying that workers had voluntarily decided to stay underground. Andrew Levy is a Labour analyst. He joins us now. Andrew, good afternoon to you. So when we have an event like this involving a large number of people, 401 workers, all of this happening underground, what kind of process do you have to go through to work out if they're guilty of an offence?
Yeah. Well, Stephen, it poses a number of very interesting questions, and the first one is, are they typifying this as an unlawful strike, or are they typifying it as a hostage situation, which is more misconduct? Now, my understanding is that they are, having started off saying it's a hostage situation, which at the time I didn't agree with, I think they're now saying it's an unlawful strike, which in fact makes it easier to sustain a dismissal in terms of the process, and I'll explain that in a moment. Whereas if they don't take the line that it's an unlawful strike, but they typify it as misconduct, then they're going to have to go through the disciplinary process in respect of each and all of them to show that that particular individual was involved and he coerced people or he intimidated people. In other words, he was guilty. Otherwise, they've got to argue something called common purpose, which I don't think begins to fly, or they're going to have to argue something like, it's a mass action and they're all guilty. But there's no such thing as collective guilt in our law. So if we take the strike route, then the argument goes as follows. This is an unprocedural, therefore an unprotected strike, because, as I'm sure all the listeners understand, that if you follow the procedure, you are protected from dismissal for the mere act of striking. You can still be dismissed for burning the factory down, but not for striking. Now, if you have or are faced with an unlawful strike, an unprotected strike, no procedure followed to declare the dispute, to give the notice, etc., then you are entitled to dismiss those workers, provided you follow, which is set out in the addendum to the LRA called the Code of Good Practice on Dismissal, and its recommendations on mass dismissals in the case of industrial action. And the burden for that is, in fact, a little bit lighter in the case of a mass dismissal. So what they would need to do is to consult with the union, to give the union an opportunity to persuade its members to end this unlawful action, to issue a clear ultimatum as to what the result will be of failing to comply with the ultimatum, give them time to consider, and only then dismiss. Now, it's a debatable point whether or not there needs to be some kind of hearing, and obviously to have 401 individual hearings when there is some collective action is a nonsense. It would take 5 years. So the issue of, well, what constitutes a hearing is a little bit loose, but I'm fairly sure that a company like Gold One would have taken professional advice, have in-house expertise, and would certainly have said to the union, before we dismiss, please consult with your members and make representations to us as to why we should not dismiss. They would have probably provided an opportunity for anyone who wanted to step forward and say, look, I was personally intimidated, I had no choice to do so, and only then would they issue dismissal notices, which may explain why it's taken some time for this to happen. But obviously, in a case like this, where the union would be highly unlikely to either win a case or get a reinstatement on the basis of the act that was done, either unlawful striking or the misconduct of the collectivity. But in point of fact, it is therefore easier for the union to say, well, we're not going to tackle that one. We'll say they didn't follow the correct procedure. Now, in a case like this, I would be very surprised to find either the CCMA or a court awarding reinstatement if they were to find against the company, and that's a big if. But even if they found some small technical difficulties, I can't see them rewarding this kind of behavior. And if they did, by way of some compensatory award, I'm quite sure that the company would appeal and the union would cross-appeal, so it would go on for a long time. So I think the chances of these workers returning to work or being rehired anytime soon via legal process is particularly slim.
Now, Andrew, you've clearly left the door slightly open for a negotiated process, but we'll put that to one side for a moment. So what you're suggesting then is that, in a way, what actually happened doesn't really matter. It's the way in which you interpret what happened. So the company has chosen the easier legal route.
That's the way it seems to me, Stephen, and you're quite right, because once you've decided what you're dealing with, the LRA specifies the procedure. So if you say it's misconduct, then you've got to follow the confines of your disciplinary procedure, which is negotiated with the union, which provides for appeals, and is a much, much more complex process. Whereas if you say, just for argument's sake, that it would be retrenchment, you follow the procedure in 189 for retrenchment. If you say it's poor performance, you follow the procedure of performance improvement program. So once you nail your colors to the mast, the procedure is given. Now, in this case, they are saying it's a collective misconduct, which is a species of misconduct, collective unlawful striking, but you aren't saddled with the same process of almost individual hearings, one way or the other. So if that indeed is what the company is doing, and, you know, I'm certainly looking at this as an observer, I would say it's probably a smart move on their part, and if I were to have been asked my opinion, it's probably what I would have advised.
We're used to protests around a workplace. People have sit-ins from time to time. I realize an underground sit-in is much more dangerous, and we've seen, this is not the only sit-in we've seen, underground. This is illegal to have a sit-in in your place of work. So is it illegal to have a sit-in protest underground in a mine shaft that you don't own?
Yes, it most certainly is. You know, firstly, if you don't own the mine shaft, but you're the operating company, then you have responsibility. If, for example, you've contracted out, then ultimately, in terms of just the common law obligations, you would be responsible. But in terms of the safety and health legislation and the regulations, which are very, very protective and specific in terms of mining, the operator has to nominate a responsible person, and that is the person who will be looked to for compliance with safety. And this is clearly a dangerous situation, a life-threatening situation, and one where it becomes very difficult to argue any form of legitimacy at all.
So in other words, and I'm concerned that we're going to see more protests like this, any form of protest underground in this way would probably result in workers being fired and the company winning any court case based on that.
That's how it seems to me, Stephen. And, you know, the fundamental difference is if they are sitting in a factory, well, if they're on strike, you can't run the factory anyway. If you try and bring in replacement labor, there will be absolute mayhem and violence. And, you know, one of the best things to do before you try a forcible eviction is to let them sit for a while, because after a few days they get tired, it's no longer fun, you've got no more songs to sing and you want to go home. And if that doesn't happen, well, then you would approach the courts, which, in fact, I believe Gold One did in this case, and they got an interdict, but the court order was ignored. So I think, as it seems to me, the union does not have a strong hand here. And it may well be that even the union privately may be saying to its members, guys, you were stupid. You know, we didn't advise you to do this. This was not something we would have recommended. But they feel, you know, absolutely bound to protect them. They have no option because, of course, if they are AMCU members, and I'm speculating, and they were dismissed because they supported an AMCU pressure tactic to get them in as the bargaining agent, then AMCU has got to defend them. If they are NUM members and they feel they're being penalized, then NUM has got to defend them. And, you know, our unions have not yet reached a state of maturity where they can say to their members, gents, if you take the law into your own hands, we can't help you. We're not there yet.
Andrew Levy, the Labour analyst, the view from him. Thank you very much.